Welcome to the final round of the 2015 Marion Rice Kirkwood Moot Court competition. First of all, this is the final round of what has been a long competition, and I want, please, if you will, to join me in recognizing all of the work by all of the teams who competed. They did extraordinary work on their briefs and an oral argument through multiple rounds, and let's thank them for all the work they did. I guess I should introduce myself. I'm Alex Scherenbeck. I am a co-president of the Moot Court Board, as is Gary Dial. The rest of our board is here. Some members of our board are here. Greg Schweitzer, Chelsea Priest, Jordan Rice, I believe, is also in the audience. Not represented are Raza Rashid and Ben Adams. Before we go further, I also want to recognize the people who are really the core of the Moot Court competition every year. Randy Fenner and Lisa Pearson. And thank you to Dean McGill, who's here, and faculty and students who've joined us. So just briefly, the topic today is, if the parties don't mind my characterizing it, because I'm sure you'll have your own version, is Electronic Arts is a big video game company, and they make a video game called NCAA Football. At least they did at one point. And the game uses the likeness of a former college athlete, a Rutgers quarterback by the name of Ryan Hart. And he sued under a state law right of publicity claim, saying that he should be paid for the use of his likeness in the game. And the question is whether Electronic Arts doesn't have to pay because of the First Amendment. Now, the format today is going to be that first we're going to have a presentation of awards, then our judges will enter, then there'll be some argument, 15 minutes aside. The petitioners can reserve some time for rebuttal. After the argument is over, the judges will retire to the chamber. They're going to deliberate on this very important issue, and then they're going to come out and they're going to tell us the results of the competition. And for that whole process, you will all be staying in the room. So no exiting from here on out. So before we then begin the next stage, please join me in welcoming Robert Olson from the firm of Granus, Martin, Stein, and Richland. We're grateful to that firm for their generous financial assistance in the Moot Court program through their Walter J. Cummings Award Fund. And Robert Olson is here to present those awards. Thank you.
Thank you. As Alex said, I'm a partner in Granus, Martin, Stein, Richland. I'm also an alum of SLS. I won't say what year. And we have, for a number of years, sponsored the preliminary rounds to this. We are all appellate lawyers. That's all we do. And so it is in our interest to encourage and recognize excellence in appellate advocacy. And to that end, we have the winners in the preliminary rounds. Best Respondent's Brief, Courtney Cotomy and Jenna Neuschuler. Come on up. Jenna, thank you. Photo opportunities. Best Oral Advocates Team, Madeline McKenna and Taylor Davidson. By the way, what they're getting now are letters. There is money associated with this, but we can no longer say that the check is in the mail. The check is electronically delivered from the law school in a manner that... and Best Petitioners Briefs, Ollie Carroll and Ian Stearns. right, Alec, I think you're back up.
So we're going to begin momentarily. Just a reminder, please turn off your cell phones if they're still on.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court. The attorneys who will answer the calendar in this case of Electronic Arts versus Ryan Hart are Michael Chen and Daniel Kane for Electronic Arts, and Philip Klimka and Matthias Weinhardt for Ryan Hart. Please be seated.
Mr. Chen?
Madam Chief Justice, and may it please the Court, my name is Michael Chen, and along with my co-counsel, Daniel Kane, I represent the petitioner, Electronic Arts. Before I proceed further, could I please reserve 5 minutes of my time for rebuttal?
Yes, of course.
Thank you. I will explain why strict scrutiny, and not a newly devised test like the transformative use test, must govern this case, and then my co-counsel will demonstrate that under an application of either strict scrutiny or the transformative use test, the First Amendment bars Mr. Hart's claim. This court held in Brown v. Entertainment Merchants that video games are protected speech under the First Amendment. Here, Mr. Hart seeks to forbid Electronic Arts from including certain facts and images in its video games. But that's exactly the kind of content-based restriction on protected speech that is subject to strict scrutiny under Brown and other well-established First Amendment precedent.
Mr. Chen, we've only decided one case in this area, and that's the Zucchini case. And as I read Zucchini, it does not apply strict scrutiny. It does something that's more akin to throw it all up in the air and balance everything. So do you think Zucchini has to be overruled in order for us to say, yes, strict scrutiny is the right answer here?
No, Your Honor. As an initial matter, it's true that Zucchini didn't explain what sort of analysis it was applying and didn't define a standard to be applied in future right of publicity cases that implicated the First Amendment. But applying strict scrutiny here would be perfectly consistent with the approach that this court took in Zucchini, because what the court did in Zucchini was to assess the adequacy of the state interests justifying the right of publicity in that case.
But we didn't use any of the language of strict scrutiny. We didn't ask to see a compelling interest. We didn't ask whether the restriction was narrowly tailored to accomplish its object. I mean, all the hallmarks of strict scrutiny are completely missing in Zucchini. And if anybody picked up Zucchini and said what standard is being applied, they'd say, intermediate, balancing analysis, nothing to do with strict scrutiny.
Perhaps, Your Honor, and it's true that the Zucchini court didn't use the language of strict scrutiny as we've been accustomed to seeing it in the decades since that case. But it's also true that the doctrine of applying strict scrutiny to content-based regulations of protected speech developed significantly in the decades following Zucchini. And so now it's clear that when the court addresses content-based restrictions on protected speech, strict scrutiny is the appropriate method of analysis.
Can I ask you a question about that? So much of the force of your brief and the way you started your argument today is to presume that this restriction is content-based, and you've relied on the Brown decision, which I understand I would too if I were in your shoes. But Brown was an easy case for content-based because that's one in which you had violent videos, and the state's concern emanated directly from the content of the videos. These are problematic because somebody watching these videos could end up doing X, Y. This seems quite a bit different because the state's interest doesn't really have to do with the content of any speech in the way that we normally think about content-based restrictions. The state interest here is just protecting somebody's pocketbook. So from that standpoint, it doesn't seem like your argument for strict scrutiny really follows, because we apply exacting scrutiny when we're concerned that the state wants to stamp out certain content of speech at the expense of other content, but that doesn't seem to be what's going on here.
What is going on here, Your Honor, is that the right of publicity restricts the content of electronic arts as speech, in that it restricts electronic arts from using celebrity likenesses in its works. And that on its face is a content-based discrimination, because whether the law applies depends on what the speaker says. And
I can understand why. I get that semantically you can describe it as content-based. That's undoubtedly true, because the content of the speech can be said to have make a difference. But I don't understand why the things that usually cause us to be concerned about content-based restrictions are really at issue here. Because what this right of publicity is trying to do at the end of the day is protect somebody's pocketbook regardless of the content of the speech. Nobody cares about the content of the speech. It's that somebody gets to preserve their entitlement to gain commercial benefit from the fruits of their labors.
A couple of answers to that, Justice Srinivasan. The first is that the right of publicity claim in this case does implicate the rationales behind the content discrimination inquiry, because restricting electronic arts' ability to use these likenesses in its works restricts electronic arts' ability to express its ideas. And indeed, if electronic arts' goal is to say, this is what it's like to be Ryan Hart, it's very difficult, impossible even, to do that without mentioning Ryan Hart's physical attributes or biographical attributes.
Well, you don't mention his name, right? I mean, why is it so essential to have his likeness in order to be able to express this message about what it's like to be a Division I athlete?
Well, Justice Kethledge, whether or not Electronic Arts feels comfortable using Ryan Hart's name, maybe for other interests. For instance, if the game did use his name, that might pose false endorsement problems. That is, the false implication.
Right, and that's not present here.
Exactly, Your Honor. And so the use of Ryan Hart's other attributes, for instance, his speed or his throwing arm, is critical to achieving this realistic fantasy universe that players can take over a Division I quarterback or play alongside a Division I quarterback. And
well,
so
why can't you just make up some composite quarterback, and give different quarterbacks in the game different sets of characteristics? Why does one have to be Ryan Hart?
One video game author might make such a game, but the game that Electronic Arts has sought to produce is a game that says to users, this is what it's like to be Ryan Hart, or to comment directly on Ryan Hart's attributes. And so,
but this is kind of a problem, and I realize that this is getting away from the question of whether strict scrutiny applies. But when you say, well, our purpose here was to have a character that was Ryan Hart, but Ryan Hart is saying, well, you're free riding on his labor, on his image, on his personality, on his characteristics. Why should you be allowed to do that?
Well, Chief Justice Kagan, the point here that I'm trying to make is simply that when the right of publicity restricts Electronic Arts from conveying the type of message that it wants to convey by restricting the content that it may use, that's a content-based restriction on speech that triggers strict scrutiny. And my co-counsel will explain why that not only doesn't involve a compelling interest, but also wouldn't even pass the transformative use test.
But I think Justice Srinivasan's question goes to there's a disconnect, right, between the basis for the content regulation and the part of this video game that it would seem you're arguing is speech, right? So in Brown, I guess we're told that these video games are speech because of these literary devices that they use and so on. And you definitely emphasize the narrative part of the game. But those things aren't his likeness. And you could have those things, as Chief Justice Kagan suggests, without having it be Ryan Hart. You could do all those same things. So the things you're pointing to as speech are not the thing that you say triggers the content regulation. So why isn't it not content regulation? It's non-content regulation.
Well, even putting aside the notion that restricting Electronic Arts from using these likenesses prevents it from expressing the idea that it wants to express, this restriction also implicates the rationale.
Well, could you just say a little bit, what is the idea? What's the idea it wants to express?
One idea is this is what it's like to be Ryan Hart. Another idea is these are Ryan Hart's attributes as compared to other college football players. And
what about the game part itself? Let's set aside this narrative business. Let's talk about the game where he throws a pass and I don't know, you have some kind of joystick or something. What message is that conveying?
Well, this court has explained that a court need not find an articulable message for a work to be protected speech under the First Amendment. And indeed, the Brown court didn't say that video games need to have identifiable messages, simply that they have communicative features, which this game has in spades.
Well, what does that mean? I mean, at least Brown said literary devices. Okay, so now that's something I can kind of grab onto. What literary devices, or anything like literary devices specifically, are communicating some kind of message when the player tries to throw the ball on a 7-yard slant?
On a play like that, the game displays characters, including the quarterback and the receiver. There's a plot as to whether the play will be successful or not. And there might even be a message of this is what it's like to play elite college football. But the Brown decision doesn't make any of those things critical to a finding that video games are protected speech, because Brown answers that question categorically.
But why wouldn't we look at this as something more equivalent to trademark or copyright, where we don't apply strict scrutiny, where we don't go through this whole compelling interest, narrowly tailored sort of analysis? We just say you can't use somebody else's mark, and here you can't use somebody else's labor and personality.
Well, this court has never squarely addressed the question of whether trademark is a content-based restriction that, when applied to non-commercial speech, triggers strict scrutiny. But in the Eldred versus Ashcroft case, the court did address copyright and explained that copyright is uniquely compatible with the First Amendment.
Well, how about trademark? Do you think if we saw a trademark case in a non-commercial setting, we would decide to use strict scrutiny?
I see my time has expired. Could I answer?
You can answer the question.
Thank you.
Because it's my question.
In the trademark context, this court might very well reach a conclusion similar to the one in Eldred, which is that trademark, like copyright, but unlike the right of publicity, has unique speech-protecting features built in that make it uniquely compatible with the First Amendment. But if the court looked at trademark and concluded that it was a content-based restriction on protected speech, then it would have to apply strict scrutiny, as it should here.
Can I ask a really quick question? Is Pac-Man speech?
Pac-Man might very well be speech under Brown's
has music,
reasoning.
Right? I mean, why would you say it's speech? Just because categorically video games are speech?
Because the Pac-Man game, as I'm familiar with it, contains the same sorts of features that Brown identified as of video games as a category. It has music, it has plot, and it has characters, and so does this game here.
All right. Thank you.
Thank you.
Thank you, Mr. Chen.
Madam Chief Justice, and may it please the Court, Daniel Kane for Petitioner Electronic Arts. As my co-counsel argued, strict scrutiny is the proper means of analysis to govern this case. But even under the transformative use test, this game is protected by the First Amendment. And that's because, as my co-counsel was discussing, this game allows users the unique opportunity to experience the world from the realistic perspective of college football players.
So can I ask you this? Suppose that what the game, we're not even talking about games anymore. Suppose that what your company does is it, in a digitized format, just reproduces an actual game in which Mr. Hart played. So it's not a video depiction of the performance itself, but it's a digitized reproduction of it. Would you say that that's something that the First Amendment would entitle you to do as against somebody's right of publicity?
No, Your Honor. If the game were entirely just a recreation of what Brian Hart actually did in real life, that, it seems to me, would fall under Zucchini's holding.
So, but why is that? Because as I read your brief, a lot of the reasons you give for why what you do is entitled to protection is that, for example, he's an amateur and he can't rightly expect compensation. That there's not enough of a disincentive because he'd have an incentive to play college football anyways. That there's no moral right because the fame that he's achieved is not a product of this, that, you know, it's a bunch of fans and all that are making him to be the big stud that he is. If that seems equally true when you have a situation in which it's just a digitized reproduction of the game itself.
Well, Your Honor, the question at the outset is whether we would analyze that question under strict scrutiny under the transformative use test. If we're talking about the transformative use test that respondents propose, then the game would be transformative and subject to First Amendment protection if, in addition to that original performance, it adds new expression through the likeness. That's what the transformative test asks. Has the artist taken that likeness and through that likeness created new expression? And that is what the game has done here. It's done that by creating these dramatic, realistic, interactive narratives and by creating commentary about the individual players. These dramatic narratives are akin to the choose-your-own-adventure novels that this court described in Brown. What this game does is it allows its users to take control of players as they enter their world of college football as a freshman, or you can take control of a player as a sophomore, a junior, a senior, and live out their life, both on the field, feeling what it's like to be a quarterback throwing that 7-yard slant, but also what it's like to be a quarterback who lives in a dorm room, who gets fan mail, who gets to go to class, who takes actual tests. This game includes actual tests, and you answer questions.
But if that's all the case, and your brief talks about this too, the interactivity of a game, but that suggests that you put anything in a game and it will pass the transformative use test, doesn't it?
No, Your Honor, it doesn't. Interactivity, as this court described it in Brown, is a mechanism, a unique mechanism of video games. Well, not necessarily unique, because also Choose Your Own Adventure novels have that interactivity. But video games use that interactivity as a mechanism to create new expression. And so, the game creates these narratives that users get to be a part of.
Well, I think you just proved my point. You basically said interactivity creates new expression, and I said, well, that means that anything interactive is going to pass the transformative test, according to you.
Well, that's not right, Your Honor, because there could be a situation where a game could have interactive elements, but there could be another character in the game who does exactly what he does in real life, and over that player, the user could have no control, and that player could live out a narrative just as he does in the real world. And in that case, that person would have a valid right of publicity claim. But if you are taking control of someone and you get to live out their life in a new and unique way, to see what their life is like and to make choices for them, that is transformative. That is new expression.
So on that, I mean, suppose we went down part of the road to Judge Srinivasan's question, but not all the way. I mean, suppose we put Hart's name on his jersey, and suppose we put a photo of his face on the avatar so that it was much more identifiably him. Would it still pass?
Yes, it would, Your Honor. That would still not be a right of publicity violation. It would be a right of publicity violation, but it would be protected by the First Amendment in this context, so long as the game did what it does here.
So at what point, and so tell me again the defining characteristic that makes something pass the transformative effect test, that makes the video game pass that?
If through that likeness, the author has created new expression. And that is what the game has done here, both in these dramatic interactive.
I kind of don't know what that means. Could you be a little bit more concrete about that? Through that likeness, you create new expression?
Yes, Your Honor. Perhaps it's clear by contrast with something that isn't transformative. The example I gave before. If a game creates new expression, and expression can be, as Judge Laval wrote in his Tort of Fair Use standard, transformation and new expression can take many forms, from commentary, from parodies. It can take different forms. But the question here is, if you have that third party in the game that isn't creating anything new, even if there are interactive and newly expressive elements elsewhere in the game, that third character may not be transformative if all the game has done is appropriate that character for the purpose of the game.
So suppose what happens then is that it's a digitized reproduction of an actual performance, and then the interactive feature is that somebody who's watching the digitized reproduction can hit various buttons and get statistics updates. So they get an update at, as of the end of the first quarter, Ryan Hart has so many yards. As at the end of the second quarter, he stands at the following place on the career Rutgers passing charts. So it's interactive because you get to get information that you wouldn't have otherwise gotten. But what you're watching is a digitized reproduction of the actual event. Is that adding the kind of First Amendment protected stuff that you think entitles you?
No, and I think your example gets at the Chief Justice's question. I think that's a really good example. I think when you can interact with the actual likeness itself and create a new story for that likeness and see what it's like to be that actual person and make choices for that person, that's transformative. But if, as in Zucchini, you're just watching someone engage in a performance, it seems like that would not be transformative if you're just watching them engage in a performance that they actually engaged in.
So you have a step in the shoes test. Your idea is where the First Amendment value of this comes from is if you're the user and you can step into the shoes of the person whose exact likeness is replicated, then that's enough. But
no, that is enough. That is sufficient on its own, but it's not necessary. It's not the only way that a game can create new expression. A game can also create new expression through commentary, which is precisely what this game does as well. It offers commentary on individual players by assigning those players individual ratings across a spectrum of categories.
I'm sorry, could you explain that one to me? What is the comment on here?
So, Your Honor, each individual player in this game is assigned a set of ratings, for instance, in a category like awareness. And what that means is Electronic Arts game designers sit in a room and they watch game tape, and they see, is this quarterback more aware of the pocket, more aware of the defense than this player? And they do that for every player in the game. And they assign a rating to each player on a scale from 0 to 100. So in this
That doesn't
case,
sound that different from the hypo I gave you, because there, in the hypo I gave you, the person can say, I want to find out where this person ranks on, I said Rutgers' career, but let's just say against all quarterbacks who are playing right now. And then the game would spit out, okay, well, they had a good quarter, so they stand 7th on the list of playing quarterbacks right now. It's the kind of information you're talking about.
It's not, Justice Srinivasan. The difference is the subjective evaluation that electronic arts artists are making about the individual players. There is an electronic arts game designer who is literally watching game tape and deciding whether this player, whether Ryan Hart, has more awareness than Tim Tebow.
I take it that estimation is based on objective information.
That is,
they might just look at the yardage and they'd say he's a better passer because he's passed for more yards.
Your Honor, that may be the way that they make the decision with respect to how many yards they list him having thrown. But there is a subjective element in determining, for instance, on a category like awareness. There's no statistic that you can look at, except maybe to look at something like sacks avoided for a quarterback. But even in that case, there are confounding variables like the prowess of the offensive line that you might have to take into account to make that decision.
Mr. King, can I ask, this is along the lines of a question that I asked to Mr. Chen, but I just wonder whether this is even the set of questions that we ought to be asking, because what I'm stuck on is this idea that you could have a game that didn't use Mr. Hart's name, that didn't use Mr. Hart's particular characteristics, that functioned in the exact same way, but where you didn't use it. And if you did use his, you would have to pay him for it, because, after all, he's the person that created this set of characteristics, and he put a lot of hard work into it. And why should you free ride off his performance and his accomplishments for nothing?
Well, Your Honor, I don't think you can make the same kind of expression if you can't actually use Ryan Hart. An example, like a film like Selma, for instance. If Selma wants to make a point about actual people in the actual world of Selma, and if they want to add commentary about the people who participated in it, and give its audience the opportunity to see the world from the perspective of the participants in the march, well, then I think the game actually does have to use those people to express its communicative impact. And likewise here, the game actually has to use its players, both to create these narratives of what it's like to actually be a college football player, and also to add commentary. It's just like a satirist simply has to use reality in order to create his satire.
In Selma, though, I mean, Dr. King is part of the message, no question about it. In your game, the likeness does not seem to be so central, again, a part of the putative expression that's happening here.
Well, I disagree, Your Honor. I think that this game does create expression in much the same way that a film like Selma does, and it depends on its avatars. In this mode of creating actual stories centered around the individual players, it matters that you're seeing what it's actually like to play with Ryan Hart, to play with his teammates.
And why don't you put the name on the jersey?
As my co-counsel mentioned, there is reason not to put the name on the jersey because it may raise the plausible implication of a false endorsement.
Of what? I mean, a lot of your arguments to the effect that there can be no confusion about endorsement would seem to apply equally if the game had his name on the jersey.
I agree, Your Honor, and I do think that Electronic Arts could include the players' names in this game. But what it's done is not included those names out of fear of potential litigation. And as this court noted in Campbell versus Acuff Rose at footnote 18, steps taken to avoid liability are not themselves evidence of liability. So a step taken to not include these players' names is not itself evidence of liability. But I agree with Your Honor, the Chief Justice, that the transformative test may be asking the wrong questions here. And strict scrutiny is asking the right questions. Strict scrutiny takes as a given that this game, under Brown's categorical holding, is protected First Amendment speech.
So there's a little bit of a disconnect, it seems to me, in the following sense, and I don't know if this gets to the standard you apply or applying the standard or whatever, just throw aside all the doctrinal stuff. One thing that seems a little bit odd to me is in Zucchini, we held that the right of publicity trumps the First Amendment interest, and that was in the context of a news broadcast. It seems kind of anomalous to say, in the context of a news broadcast, the First Amendment doesn't operate in the way you want it to operate, but in the context of a video game that's just seeking commercial exploitation, that all of a sudden there's these grand First Amendment interests that kick in and say, oh my gosh, we have to make sure that the video game people get to do what the video game people want to do, or else society is going to suffer some dramatic consequences.
No, Your Honor, the First Amendment value of the speech is identical. As this court held in Brown, video games are treated just like news. They get First Amendment protection. The question and the difference between Zucchini and this case is how compelling the interests on the right of publicity side are. And in that case, in Zucchini, the interests in the right of publicity were admittedly much stronger than they were here. That case was rightly decided. That case, there were real compelling interests to trump the First Amendment, because in that case, you had a performer who had his entire performance taken away and given away for free. And what that meant is that Zucchini was going to lose compensation because people were no longer going to would no longer have the same incentives to come see him that they otherwise would have. And he, therefore, would be less incentivized to keep making his performance. By contrast here, once this game comes out, the incentives to participate in college football don't change at all, and the compensation that players receive to play college football don't change at all. In other words, the players haven't lost money as a result of this game coming out in the way that the players did.
You'd say this gets back to my first question. I think you could say the exact same thing about a digitized reproduction of an actual performance. You would still stand up and you would say, and I think with some force, that the incentives don't change at all. It doesn't matter that there's a digitized reproduction of the game. The college football athlete is still going to play college football. It doesn't matter that there's a digitized reproduction. It's not going to affect the quarterback's incentives at all. It doesn't matter that there's a digitized reproduction. He's still an amateur, so he can't expect any compensation from the performance. So all those arguments still seem to apply.
Well, I think it might in that context. I think that if the game actually did just recreate actual performances, I think that does diminish some of the incentives people have to support college football more broadly, like actually go to games. But I do think that, like your example, I think what this game actually does is far from diminish the incentives of the players. I think it actually augments the players' incentives in a way that perhaps your example would not. This game actually...
But I think you're ignoring the point of that question, which is to say that the incentives really do function similarly. Nobody's going to stop playing college football because you use their actual likenesses in a video game. So why did you answer those questions in the way you did at the start of this argument?
Because, again, as I mentioned in the beginning, I think the question is whether we frame this as a transformative question or a strict scrutiny question. And I think under the transformative test, there's a difference between those two kinds of broadcasts, one that actually replays the actual game and one that adds...
But just why ought there to be that difference?
Well, Your Honor, we actually don't think that the transformative test is the proper mode of analysis.
So you would have us go all the way then?
We believe that this court ought to adopt strict scrutiny as its standard to govern.
But forget the standards. You would have us say that in the hypothetical that Judge Srinavasan gave, that would be absolutely fine for you to do.
If the participants in that game could articulate a way in which they... I see my time has expired. May I finish?
Please.
If the participants in that game that you described could articulate a harm that they suffered as a result of the distribution of the game, then the right of publicity would be remedying a harm. But if there's no harm, if they can't articulate an actual compelling interest, then that game, too, must fail under strict scrutiny. For that reason, the judgment of the Third Circuit should be reversed. Thank you.
Thank you. Mr. Klimka?
Madam Chief Justice, and may it please the Court, my name is Philip Klimka, counsel for Respondent Reinhardt. I will first argue that a transformative use test should apply in this case, not strict scrutiny or the Rogers test. My co-counsel Matthias Weinert will then demonstrate that Mr. Hart prevailed under the transformative use standard. The transformative use test is the only test that balances the relevant interests at stake while at the same time recognizing the close analogy between the right of publicity and copyright that this court identified in the Zucchini decision.
Well, I think you have to first confront the question of why this isn't just a content-based speech regulation.
Your Honor, it is not for two main reasons. First, because we know from this court's decision in Zucchini that when the right of publicity conflicts with the First Amendment, the two must be balanced, and that the First Amendment...
Zucchini certainly suggests that it was not doing strict scrutiny, but I guess what I'm asking is why isn't Zucchini wrong? That Zucchini should have been doing something else. We have made very clear that content-based regulation demands strict scrutiny. Why isn't this content-based regulation?
Zucchini was correctly decided because it pointed to the underlying state interests, drew an analogy between those state interests in terms of the right of publicity and copyright, and with that paved
We don't
way.
usually look at the interests to decide what standard we're applying. We usually look at the interests after we decide on a standard to decide whether the interests meet that standard. We usually look at other things to decide what standard we're applying, and in the First Amendment context, what we look at is we say, is this regulation, is this speech restriction going to content or not? If it's going to content, it gets strict scrutiny. So it seems to me you have to show us that this is not going to content in the usual way. Am I wrong about that?
Your Honor, it is not going to content in the usual way, and I'd like to explain that. Petitioners are framing it as a content-based in application, but it is fundamentally different because the underlying government purpose here, the government purpose here is not to ban speech, but to protect a right, the right of publicity. And there are incidental effects on speech based on content, but it is not content-based in the government's
But
motivation.
I always thought that all these content-based rules were ways to think about purpose without actually thinking about purpose. In other words, we don't ask about purpose directly. What we do is we just say on the face of the restriction, whether it's a statute or in this case a tort action, does this regulate content? And one of the reasons we ask that question is because we think that content regulation is more likely to have a bad purpose, but we don't only apply the strict scrutiny standard when we find a bad purpose. Rather, we look at the law on its face.
Your Honor, it is our position that there is a second line of cases, starting with Ward v. Rock against racism and City of Renton as well, where there is a more direct inquiry into the government's purpose. And it's our position that this case presents a unique opportunity to deduce the government purpose without having to trust the government. Because in this case, the restriction is not targeted at the communicative effects of the speech. It is targeted at secondary effects, namely the lack of compensation for Mr. Hart in this case. And in cases like that, we can actually test what is the government's real purpose, because we can ask, is the law over-inclusive and is the law under-inclusive?
Well, I mean, this isn't like a time, place, or manner restriction, in fact, because if Hart wins, this speech doesn't happen. I mean, that's the reality. I mean, do you dispute that?
Yeah.
It's not like they can do this on Tuesdays but not Fridays. It's just simply not going to happen. You've asked for an injunction.
Your Honor, we were all inclusive in our prayer for relief. At this point, we're asking for damages, and we're not asking for an injunction any longer. But I would like to point out that there is that friction. Some cases have looked more directly at government purpose, and then there are cases that have not done that. And this court in Simon & Schuster, which Petitioner points to the most analogous case, has left open the opportunity of looking at these kinds of cases through the lens of through the Ward and City of Renton lens of inquiring more directly into government purpose. It has said in that footnote that the only reason it did not employ that mode of analysis was because in Simon & Schuster it recognized the law was over-inclusive.
Well, let me ask you this question. As I read your brief on page 12, you concede that this game is part of the speech that enjoys the highest form of protection. Are you aware of any case in which the court allowed suppression of that kind of speech because somebody had a good purpose, a purpose on par with the New Jersey right of publicity?
Your Honor, I would point to this court's decision in Zucchini. It was the highest level of First Amendment protection. It was a news report.
It didn't seem like they were applying the highest level. Is that the best case you have? That we can suppress speech that enjoys the highest form of protection so long as somebody has a good reason.
I would point to both the Zucchini decision and, again, the analogy to copyright law, and would point to Eldred v. Ashcroft, which has said that when a test already incorporates First Amendment principles, like the test that we propose, the transformative use test, it dispenses with the need for strict scrutiny because it is already responsive to First Amendment.
Why shouldn't we just fold this New Jersey right of publicity interest into the strict scrutiny test? Why? I mean, what's so special about this New Jersey interest that it gets a pass from strict scrutiny based on content regulation, and instead we're just in this sort of, balance zone?
Well, it is the state interest is the same state interests that this court pointed to in Zucchini that demanded a balancing test, and it's this dual interest in preventing unjust enrichment and also in incentivizing people to enter the public sphere and provide a valuable public good.
I thought the First Amendment runs over interests like that routinely, and still those interests aren't good enough to suppress speech.
Well, Your Honor, it didn't in Zucchini, and it doesn't in cases of copyright.
But copyright, I mean, that's in the Constitution. Obviously, we have to make an accommodation with that provision. We don't with the New Jersey right of publicity.
Well, but the decision Zucchini has, in a way, elevated these state interests and the right of publicity, at least to a point where it said that the First Amendment does not automatically trump the right of publicity, and where we do need to engage in a balancing analysis.
So the First Amendment did trump in Times versus Sullivan, and one thing that seems a little bit strange about the argument you're making is that because of the First Amendment, public figures don't get much protection at all as against defamation. But under the argument you're making, public figures get all the protection in the world as against famation. It's like speech that celebrates, right? And it just seems kind of odd to say that when you're a public figure, you're stuck if somebody's defaming the heck out of you.
Well, Your Honor, unlike privacy rights, what's at issue here is not an emotional harm or reputational harm that Mr. Hart is asserting. It's a commercial misappropriation of his likeness and as applied of conventional depictions of his likeness. And so that interest is very different from the interest protected by privacy laws. And in the right of publicity, it wouldn't make sense to allow misappropriation. The higher the value is, the more value a depiction has, the more easily it can be misappropriated. And because they're fundamental different and closely...
I mean, I get that they're different, but I guess what I'm asking is which way the difference cuts, because it just seems a little bit odd to me to say that what we really prize and what we ought to value is to make sure that somebody doesn't get celebrated too much, because then they get to gain the commercial exploits of that, as opposed to we're really worried about the fact that somebody's being defamed, which seems like...
Well, in a way, I mean, we're worried about the incentive rationale of incentivizing people to come forward into the public sphere and provide a valuable public good, a public persona. And
well, would Mr. Hart have done anything different here?
Yes,
would he have stopped playing football?
Well, Your Honor, Petitioner contends that he already loved playing football and he would have done it anyways, but our response is that an incentive...
He didn't love playing football?
He did, but an incentive rationale does not need to be a but-for cause. Just like in copyright, we would not expect musicians all of a sudden to stop producing musical works if they're not protected by copyright. Musicians love producing music. In this case, Mr. Hart did have to make hard choices. He had to decide between spending countless of hours training, risking injury, versus pursuing his academic interests.
But can we even imagine that Mr. Hart's decisions would have been different if this game weren't able to use his likeness?
Your Honor, it is not only about this game, it is about the right of publicity, and that is an incentive that factored into Mr. Hart's decision. And if we eliminate the right of publicity, the marginal utility of every additional depiction of a likeness would go to zero, and Mr. Hart could not monetize any of that.
I don't understand this argument, because he signed all of these rights away, right? I mean, this is the worst vehicle imaginable for this claim.
Your Honor, he did not sign all of these rights away. He entered into a voluntary agreement with the NCAA
right.
to
That's what I'm talking
temporarily not monetize that right. But because it is a property-based right, and New Jersey defines it as a property-based right, I think an analogy to real property is pertinent. A landowner who owns a piece of land and chooses not to cultivate that land does not give someone else a right to trespass onto that land, cultivate it for him, and then reap the benefits without compensation. I almost
wonder if the incentive is running the opposite direction, because it seems to me if you're talking to somebody who's potentially going to play college football, or let's say high school football, and you say, hey, I got an idea. If you play football, you can be featured in a video game. I think somebody says, whoa, I'm playing football. Right? It seems like the incentive is actually cut in the opposite direction.
Your Honor, for some players that might be true, but what we're now discussing are these secondary effects that Petitioner has put forward, that maybe it's enhancing through some indirect means the value of his persona. That there's no evidence for that. Mr. Hart clearly did not care as much about being in a video game for the coolness factor, but he wanted to monetize conventional depictions of his likeness, and that did factor into the incentive rationale.
And for what purpose exactly? Was he going to create his own video game?
It's possible that he would have licensed his likeness to other video game companies, or in a world, of course, that's not possible if the right of publicity is not enforced and Electronic Arts is using his likeness without compensation, but he could have licensed it to Electronic Arts or to other video game companies. And I'd like to...
Can I ask you this question? So suppose you have a speech by a public official and it's rebroadcast in a documentary. Would you say that public official has a sacred right of publicity that would prohibit the documentary producer from rebroadcasting it as part of the documentary?
Your Honor, you likely would have a right of publicity. As I mentioned, it should not... The increase in fame should not generally diminish the right of publicity. Now, we could imagine, like in defamation or other...
So you think the documentary producer has no First Amendment entitlement to reproduce the I Have a Dream speech as part of a documentary about the civil rights movement?
Your Honor, first of all, a documentary, like other movies or news report that do not copy a whole performance, would pass our transformative use test. There are discernible messages that are added to the depiction that transform the depiction itself, in most cases, in a documentary. And so there wouldn't be that problem because the First Amendment would actually win. The test we propose is not hard to pass. There needs to be just some discernible message that transforms and adds new meaning or expression.
It seems to me that the most compelling documentary about a signal moment in history like that is one that does nothing other than reproduce it. And maybe the message at the beginning is, I could try to muddy this up by giving you a big song and dance about how important this was, but I think there's nothing as poignant as just reproducing it for you so you can get a feel for what it was like.
But even in the movie Selma, for example, there were copyright restrictions on including exact words of speeches, and so that is not unique to the right of publicity to put some restrictions on that. Now we could imagine narrow exceptions for elected officials if the court chose to do so, but here we're facing a fundamentally different situation. We're facing an amateur college football player who was hoping to monetize unconventional depictions of his likeness. And I'd like to briefly turn to the mechanics of our test, because we do propose a modified transformative use test that looks at the depiction in isolation, then at context, and then also includes intent.
I didn't really understand the difference between your modified test and the test that has been used in some of the lower courts. Can you give me a case which would come out differently under your modified test and the test that's been used?
Your Honor, our test closely resembles the tests that have been applied in Comedy 3, for example. Modified, it clarifies the use of context, and that context needs to apply to the depiction itself and not look at the work as a whole. And so there's some courts who have, in our opinion, misapplied the transformative use test.
So, but just give me a kind of case that I can kind of hang this on.
I can give you a kind of case that would come out more clearly under our test. And so that is the Andy Warhol depictions of Marilyn Monroe that were mentioned in the Comedy 3 decision. And the court there identified that the careful manipulation of context changed the message of Marilyn Monroe in that context. But we realized that these are subtle decisions that courts might not always be so obvious to courts.
I wanted to ask you about that specific example. I mean, is that the kind of judgment you're asking us to make?
No, Your Honor, and we have added a third step.
It seems to the second step of your test does seem to bring that out, and the things that you're arguing do seem awfully similar to talking about manipulation of context. Am I mistaken? Am I misunderstanding your test?
No, Your Honor, but it is our position that these...
Okay, I'm not mistaken.
No, you're not mistaken.
So you're asking, what if I think I'm totally unqualified to make judgments about distortion and manipulation of context? Should I proceed to do that anyway?
Two responses to that. The first is that it is no different from complicated fair use inquiries. And when the interests are weighty here, and... Sorry, I see my time's up.
Yeah, please.
When the interests are weighty, we cannot expect a test that is...
I knew that was coming at some point.
A test that is always the easiest to apply in every context. But courts are well equipped to make these decisions. They're making them in fair use inquiries. And we have added a third factor that in that case would ask, do we have objective evidence of consumer intent, consumers purchasing it because it's a conventional depiction of Marilyn Monroe?
That we're used to discerning, but manipulation of context is troubling. But I think time's up.
Thank you, Your Honor.
Thank you, Mr. Klimka. Mr. Weinhardt.
Good evening, Madam Chief Justice, and may it please the Court. I'm Mateus Weinhardt with Respondent Mr. Hart.
I want to first follow up on the conversation you just had with my co-counsel about manipulation of context. And manipulation of context, for instance, happens in parody. That would be a case where, for instance, there have been numerous skits recently parodying Marshawn Lynch and Richard Sherman and the way they contrast in giving press conferences. And in that case, it's not the depiction itself. Visually, they try to replicate closely what those individuals look like. But through changing the context that they appear in, putting different words, changing the situation, that's the kind of manipulation of context that creates parody.
I'll bring this down to a very concrete level. I understand that manipulation because sometimes it makes me laugh. But I find it much harder to make a judgment between, or to distinguish between a charcoal sketch of the Three Stooges and the Andy Warhol T-shirt. Or the image, of Marilyn Monroe that we've all seen. And it seems to me your test, step 2, does require us to make those kinds of aesthetic judgments. Am I mistaken? And if so, how?
No, Your Honor. Step 2 does ask courts to evaluate that. But in close cases, you described examples where it may not be clear. And that's where the third factor comes into play.
Well, but you're telling me you're advocating a test whose second prong is not capable of application by most judges.
Your Honor, it's capable.
But it's okay because there's another prong. But yeah, go ahead.
It's only not capable of application when there's incredibly close cases where it is unclear whether manipulation of context might rise to the levels transformative.
This case seems kind of hard in this respect, doesn't it? Manipulation of context. They're bringing in interpretation, all right? They're bringing in interpretation to his objective data and what they see on actual film. They're interpreting his qualities, and then they're taking that interpretation and applying it to a whole new set of circumstances that the game player creates. That seems to me sort of like the Andy Warhol thing and not the Three Stooges thing. But isn't that a pretty tough judgment?
Not in this case, Your Honor. They have pointed to the fact that game designers are making, in some sense, there's some subjectivity. I would call it perhaps there's some inaccuracy in the judgments. Electronic Arts does not dispute that they are aiming to replicate reality as closely as possible, and every year they're able to do that better than the year before. In that sense, these subjective assessments are not some creative effort as much as they are a necessary evil because of the limitations of the technology.
Why aren't they themselves speech? It's the game designer's assessment in sort of a numerical way of the relative qualities of these different players. People argue about this all the time, right? Tom Brady is more accurate than Aaron Rodgers. That's speech. Why isn't that just a sort of a numerical version of that speech?
Your Honor, it is speech, but it is speech which fails to transform Mr. Hart's likeness because it is aiming to replicate reality, and it's doing it very, very well. For instance, a T-shirt, if an artist renders a drawing or if I make an action figure out of Mr. Hart, there may be some subjectivity and people might disagree on whether I made his proportions just right. But that itself cannot be transformative because that would render a whole host of things transformative. For instance, if Electronic Arts now decided to make an unauthorized Harry Potter game, and their version of Harry Potter maybe had some slight differences in the way they interpret the character, under Petitioner's argument, they could do that without any permission because those minute judgments alone render transformative.
I thought you were going to answer Judge Kethledge's question by saying that it's definitely false speech because Aaron Rodgers is absolutely more accurate than Tom Brady. but
I'll voice no opinion on that matter.
But along these lines, you look at our opinion in Zucchini, and one thing that the court said over and over and over is that there was a replication of the entire performance. And so it seemed like what was really going on is the concern was that there's a substitute for the on-field performance that would lead people not to go to the on-field performance. Because why go see somebody get shot out of a cannon if you can just see the video replication of that right away? You're not going to have the same incentive. So that's why we kept talking about replicating the entire performance. This is nothing like replicating the entire performance. It's fields apart from that. In fact, the one thing we know they're not doing is replicating the performance because what they're doing is they're giving you a character who's the same character, but then you're manipulating them to an entirely different type of of performance.
Your Honor, it's true that users manipulate it. And that's, in fact, the only thing that they can point to, because it seems like petitioners have conceded that if there were no user interaction, just replicating those performances themselves, if the computer is just doing all of that, that would not be transformative. And they say it's the user interaction that supplies the transformative element. But that kind of user interaction is no different than playing with an action figure version of Mr. Hart. Of course, users can do all kinds of things. And video games many times do use interactivity to supply narrative elements, to supply literary figures. In this case, there is none of that. Sports simulation games, in that sense, are a bit unique in that they are just trying to replicate what Mr. Hart can do. And whatever the user is doing is not any story, any plot, any narrative that Electronic Arts is telling.
But you can't deny that it's not going to dissuade anybody from going to a genuine event, which seemed like that was the concern in Zucchini, because this is far afield from that concern.
Your Honor, it's true that this is not so much a case of actual substitution. Right. But in the same sense, copyright cases and the market harm in those cases is not always based on actual substitution, but also on impairing the market for potential derivatives. So that would be more akin to what's going on here. People may still go see Mr. Hart, but he doesn't have the same incentives as a result of having reduced opportunities to commercialize his likeness. So
incentives to do what?
So again, it was the same conversation you were having with my co-counsel.
I don't want to just.
Which
you're
is
talking about the same point there.
Yeah. My response to that is that the incentives for Mr. Hart might not change hugely, but we don't know that for sure. And for Mr. Zucchini, it's not clear that everyone who goes to the state fair is going to watch television and see his performance and they say, you know what? I've seen it on TV. When I go to the state fair, I'm going to make sure to walk as far away from Mr. Zucchini as I can. So in both cases, I mean, there's some question about how much economic impact will this actually have, and that will certainly play into the damages calculation.
Mr. Weinhardt, I just went to see American Sniper, so I'm wondering what you think of that. I mean, this is a movie that's based on a particular soldier, a real soldier in Iraq, and essentially appropriates his life. And let's say that they didn't pay anything, there was no license or anything like that. How would that come out under your test?
Under our test, those kind of depictions are transformative, Your Honor. And plenty of movies do this kind of thing. Social Network, Selma, they depict real characters. But they are telling a story with that.
Well, let's suppose that they did the exact same thing and they put that soldier in a video game. It seems to me like many video games are just like that. How about then?
Your Honor, many of those video games do use their interactivity to tell stories. There is still a plot line in a script that video game writers have to write in that case.
Well, isn't there a plot line in the script here, too? You know, how the game goes.
No, Your Honor. That's more akin to just recreating the physics of the world, what Electronic Arts has done. Now, there are some ways in which we could envision them writing a script with how the game goes. For instance, if they made a game where there's a specific campaign for each college football team, where they selectively inhibit the freedom of players at certain times. For instance, in the very first game, a key player gets an injury, but the user has to control the team through that and tell the story of how the team triumphs over that to win the national championship. There is a way to combine those elements.
Tell the story there. If all the game does is it selectively excludes one player, and then you just got to keep playing the video game like anybody plays a video game, do you consider that to be telling a story?
It would be closer. No, what I'm envisioning would not just be that, but there would be narrative and commentary related to that. Cutscenes in between, commentators commenting on the progression of the
When
players.
I hear you say that, it makes me think that Judge Kethledge is right. Do we really want judges to be asking these questions? You know, what's enough of a story, and where is there enough a latitude, and where it just seems just a really hard test for judges to apply, and that makes me think that it's the wrong test to apply.
Your Honor, it's no different from transformative use questions in the realm of copyright. We are focusing again on the kind of law school examples where it is the closest and where there are very close lines. But for instance, if there's a copyright case asking whether a rap song sampled from another song and whether that sample has been transformed, those are difficult questions to answer. And in some close cases, that might better be answered with expert testimony, with juries who can comment on the particular features of the medium and who can make those kinds of distinctions. However, the problem here is that this was decided on summary judgment, and the district court
found for Electronic Arts incorrectly. And we believe that on the record before us, there's enough evidence that there is no transformation whatsoever of that kind. Electronic Arts...
Can I ask you just one brief question, hopefully? Let's say the designers look at the same body of data, film, statistics, whatever, as they look at to make this game, but instead they write a book series called Great Games That Were Never Played. And they write a book where, let's say, the book has chapters, and it's games between teams that never played each other, at least during the time they had these players. So it's Rutgers against UCLA, Michigan against Texas in some year. Games that didn't play, but it's their interpretation of how those players would have interacted and how the game would have come out. Is that protected under strict scrutiny or not?
Your Honor, if I may answer that question,
Sure.
Looking at under the transformative use test that we're arguing for.
Okay. Well, I'm sorry. Yeah, frankly I get confused with this stuff, but go ahead.
Okay. Just wanted to make sure I wasn't going to be totally evading your question.
Right. So is that a transformation?
Yes, we believe so. I mean, that's exactly the kind of thing we're looking here. If they're telling specific stories, these are particular games we've selected, and we're going to tell the story of what happens, that would be transformative. Here, they're just providing the players with the raw tools and saying, discover it for yourself. And that's the difference.
The same thing. You're just, it seems to be a written version of the thing the game does, except the players get to choose what teams are playing each other and some of the other parts.
Your Honor, I disagree with that, because for Electronic Arts to write that book, they would have to sit down and think specifically about what do we think would happen in this game? Which matchups do we want? Like, how is it going to play out? They don't have to think about those things when they make the game. They put in some input variables, and then it's up to the user to decide. It's more akin to...
I'm a little bit confused. So if you create, this is an interesting hypothesis. If you create a potential matchup that doesn't exist in the real world across generations, you want to compare the best Oklahoma team from the 1950s against the best Alabama team from the 1980s, which never could have actually happened, but EA Sports gives you a chance to play that game out. That's telling a story?
That's getting closer to telling a story, yes, Your Honor.
And how is that more telling a story than what's going on now?
Because Electronic Arts has actually decided to do something different than just replicate reality in that case. There, they would have had some kind of fictionalized narrative to that.
I don't understand what the fictionalized narrative is, because they're replicating reality. They're just allowing a matchup that couldn't have existed in reality. And here, they're doing the same thing. They're replicating reality in the sense that they're using real players, the avatar of real players, and then they're allowing people to kind of play out a game that never existed in reality.
The difference is just the degree to which Electronic Arts is choosing, making choices for the players. Again, it's the difference between writing that novel is choosing particular scenes or a movie where there has to be some selection and arrangement of that material. In this case, there isn't any of that.
Suppose there's no transformation at all. Suppose that there's a newspaper in New Jersey, and after every Saturday game, the newspaper runs a film montage of all the greatest plays of Mr. Hart, puts it all together. And this happens week after week after week. Do you think, and there's, no transformation, does Mr. Hart have a right to come in and say, I need to be paid before you can run that?
No, Your Honor. On balance, I would say no, because the purpose of that is still not it is not just taking Mr. Hart's likeness and trying to commercialize that. It's making a choice about what his best plays were. I think that the way we understand it, that would be transformative, because they are casting it to a different purpose. They are trying to
just because they're editing? I mean, they're taking the very best stuff he has to offer. I would think that makes his claim even stronger. You're taking the best plays, the ones that I've, spent the hardest working on.
Your Honor, I think those kinds of news reporting type purposes, we view those as transformative, because the value of those is to inform the public about those accomplishments.
Oh, well, then you're just saying there's speech and there's speech. Then you're just saying there's the kind of newsy speech and there's video games. But I understand that point of view, and there seems to be running a little bit underneath the surface in this case. But I think you're precluded from saying that by EMA versus Brown.
Your Honor, it's not that news is somehow categorically different as speech. It's just that it's so much easier to render it transformative in those types of contexts. Because sports video games, again, many video games will be transformative. If I may
Please
finish the thought. Many video games are transformative in the way they tell story. And there are many stories that Electronic Arts would like to tell that they can still tell. They can still give people the unique experience of playing as a fast quarterback, a rushing quarterback, like feeling what it's like to step onto that field for those of us who don't have that athletic prowess in real life. The only thing that we're contesting is that they should not dump Mr. Hart's likeness into that game without paying for it. Thank you, Your Honor.
Mr. Chan.
Thank you, Madam Chief Justice. Just 3 points in rebuttal. First, this work is transformative. Second, the transformative use test, however, is flawed. And third, the appropriate analysis is strict scrutiny, and under that analysis, respondent cannot meet his burden. As to the first point, this work is transformative because it creates new expression using Reinhardt's likeness. Now, counsel for respondent argues that the game isn't transformative because it's realistic, but realistic works can be transformative too. Realistic works, for instance, can comment on reality, and this game does that by using the player ratings that Electronic Arts subjectively creates and highlighting the pageantry of college football. And realistic works can also add perspective to the new world, and this game does that by putting users in the shoes of real college athletes. But indeed, it's tempting under the transformative use test to punish works for their realism. And so that's the second point, which is that the transformative use test is a flawed analysis. It's unprincipled because it relies on a false analogy between the right of publicity and copyright. And the two doctrines are distinct because, as this court recognized in Eldred, copyright has a number of unique features that make it distinctively compatible with the First Amendment in the way that the right of publicity is not. But the transformative use test is also unadministrable. It requires judges to inquire into the nature of art and look at whether art has enough value or message or expression to be protected. But that ignores Justice Holmes's warning from a century ago that it would be a dangerous undertaking for persons trained only in the law to constitute themselves final judges of the worth of art.
Isn't the transformative use test, it's a part of fair use, right?
That's true, Your Honor.
And courts apply fair use all the time.
That's true, Your Honor.
So you're talking about a part of a test that courts apply all the time and saying that it's inadmissible.
Courts that do apply this test as a result of the statutory requirements of the Copyright Act apply it to some criticism, to some inconsistency. And because the transformative use test...
No more than lots of other tests in the law.
That's true, Your Honor, but the unadministrability of the transformative use test means that there's no reason to depart from the usual analysis that this court conducts for content-based restrictions of protected speech and adopt this newly devised test that both rests on a false analogy to copyright and is no easier and, in fact, more difficult to apply than the standard strict scrutiny analysis. And so my final point in rebuttal is that strict scrutiny is the appropriate analysis to apply. This is a content-based restriction on its face. It prevents Electronic Arts from including certain content in its works. And indeed, supporting that conclusion, this restriction does get at the rationales behind the content-based discrimination inquiry, not only for the reason that I mentioned earlier, which is that this restriction would prevent Electronic Arts from expressing its ideas, but also because this sort of restriction lends itself to censorship, allowing individuals the monopoly power to deny pre-approval to artists who seek to depict them in works does raise the specter that only certain...
Oh gosh, I don't think that that's right, Mr. Chen. I mean, the idea of content-based being a protector about censorship is an idea about government censorship. It's an idea about government approving and disapproving ideas. That's not involved here at all.
But the government, through the right of publicity in this case, gives an individual that power. And whether that power is wielded by an individual celebrity or wielded by the government, the effect is the same, which is that speakers like Electronic Arts may not be able to express their ideas. Realistic works like documentaries and biographies and satire, which are protected under the First Amendment, may not be able to carry out their artistic and creative goals.
Well, the adult movie theaters in Renton weren't able to do that either. But we said, well, this is a secondary effect, and that makes for a different kind of analysis. And why shouldn't we think the same thing is true here?
Because this is a very different case than Renton. The law in Renton, as the court emphasized, was merely a time, place, or manner restriction on those theaters. It regulated the locations of the theaters rather than whether the theaters could exist at all.
But it did it by reference to the content of the speech.
That's true, Your Honor, but the Renton exception seems to only apply when there's that time, place, or when the law doesn't suppress speech itself. And this court has recognized that the first step of the Renton inquiry is to see whether the law is a time, place, or manner restriction. In this case, it's very different from Renton and also different from Zucchini. In both of those cases, the issue wasn't whether the speech could be produced at all, but as the Zucchini court put it, who would do the publishing or who would do the broadcast. But in this case, it is very much at issue whether this game can reach its audience at all. And so in order to restrict this game, the respondent must identify compelling interests sufficient to overcome the First Amendment protection that this work receives.
This case isn't about whether it can reach the audience at all. It's about whether you have to pay.
But Mr. Hart, through his right of publicity claim, does assert the power to deny that permission and refuse the payment. And even though the respondent abandons that claim here, it's still part of the claim, and therefore the decision of the Third Circuit should be reversed.
Thank you, counsel. Thank you, counsel. We good? Please be seated. Well, congratulations to you all. So I heard a big round of applause as we left, but why don't we do it again? And really, we mean it. All three of us. The reason we took so long back there is because we thought you were all splendid, and we had a tough time making these choices that we have to make. And if it's not giving too much away, I'll tell you that in fact we were not unanimous on any of the three awards that we're giving. So that means it was close. You all did an excellent job, and you should. And you know, I was a dean of a law school once, and I know how hard that people work to get here, and how hard the four of you worked, and it showed. And you should feel fantastic, and you should feel, all four of you, as though you did a really terrific job, and with a hard panel. You know, we weren't, you know, it wasn't all fun and games up there. I think we treated you like real lawyers, and we expected you to answer the toughest questions that we had, and you did great. So, you're not even listening to me because you're thinking, but who won? The best brief, again, by a very slim margin, is the Hart brief. The respondents, yes? Is that the idea? The best oralist is Mr. Chen. And the best team is, again, the Hart team. So I'm going to ask each of the judges up here to make a few remarks. Judge Srinivasan, as you know, was once at this table, doing exactly what you're doing. And he became one of the great Supreme Court advocates of our time. So he'll tell you how it's done.
Boy, that's really hard to say anything after that. From one of the great justices of our time. And So hearty
Judge Srinivasan doesn't want to get reversed.
Hearty congratulations to all of you. Really, really terrific performance. And I guess typically one doesn't have the ability to compare moot courts across years, and we're used to saying, you all were terrific and you should be really proud of yourselves. But I can actually honestly say that you were a lot better than the moot court competitors in 1994. Because I was there, and I thought we were pretty good. And I will say that the most outstanding individual advocate was my brother-in-law, Brad Jundev, who's here, and so any deficiencies are not due to him; it's due to me. But as a comparison, I'd say the four of you performed exceedingly well. And to me, what you displayed at a very young, tender age, at a green time span for you as a lawyer, is some of the hallmarks of excellent advocacy. And first of all four of you were unflappable. And I got to say, in this kind of setting, an environment like this where the gallery's full and you've got three people who are wearing very intimidating black robes, and it's really, really a credit to all of you that you were able to come up here and in a very calm, measured, unflappable way deliver your argument. So that's hard to pull off. And I've seen a lot of these moot courts where the nerves really shine through in a way that yours didn't. It's very easy to tell people don't be nervous, which is terribly unhelpful advice. And the only thing you can do to get over nerves is to master your craft, and all of you did that to great aplomb, I thought. Another thing that I would say that is a hallmark of really stellar advocacy that you all displayed was you actually took time to understand the question and respond to it, because you all came up with a plan of what you were going to do. But when we interrupted you with questions, you didn't just revert immediately back to the talking points that you had before. You actually took a pause to listen to what the question was about. And in fact, I thought this was kind of endearing. A couple of you sort of had this body language that was, okay, let me just pause for a second and try to contemplate exactly what was laid before my feet, and I'm going to try to respond. And I think that's really healthy because it signals to the judges that you are actually engaging with what they're asking you, and that makes us feel good about ourselves, which is really the whole objective here. And so those two things were terrific. A third thing was that you didn't come up here and just argue cases. And I think that's really, really, especially for young lawyers, what we're used to doing as a young lawyer is reading cases and trying to analyze cases, as opposed to coming up with principles and arguments and persuasive reasons, not quotes from cases. And all four of you were exceptional in that regard too. And this was a tough case. There's really powerful arguments on both sides, both for and against you, and you guys did a great job of seizing on, I think, the best reasons to rule in favor of your position, as opposed to the fact that there's a case out there or a set of doctrines out there or a set of lower court decisions to support your view. So all in all, terrific performance. You all should be really, really proud of yourselves. You really served your fictitious client exceptionally well. Congratulations.
Well, I certainly agree with. Is this working? Okay, now it is. I guess the entire argument I was not close enough. But I certainly agree with everything my colleagues said. I really do want to emphasize how minimal the differences were between the performance, both in the briefs and in the oral advocacy. We did have a disagreement about how these came out. That is uncommon in my experience, and that's because this was so close. I thought that each of you just did a remarkable job. I don't think I was even able to ask Mr. Kane a question because I just couldn't figure out a way to penetrate what you were saying. And I give you credit, and I was sort of a little embarrassed myself. But I mean you just did an exceptionally good job. All of you did. I think that each of you has a conversational argument style, which is exactly what you want to have in an appellate argument. It really isn't an argument. It's a conversation. I think each of you were good listeners, and I would reiterate what I think Sri said about the absence of talking point type responses. You seem to think about the questions and answer the question itself rather than just sort of spit something out that had been prepared in advance. Maybe it was, but if so, it didn't show. And I think each of you did a notably good job of answering the question. That is something that is sometimes more difficult to get attorneys to do than one might think. But each of you answered the question, and I think recognize that the questions are an opportunity to understand what the court's concerns are with your position, and that's something to embrace and to answer and to never leave unanswered, because the goal is to win, not to avoid embarrassing yourselves. And each of you, I think, did a great job of grappling with the hardest parts of your cases rather than trying to sidle over to some other issue. So I give you, all four of you, great credit. All four of you really should be proud of yourselves.
The problem with following people like Judge Srinivasan and Judge Kethledge is that there's not much left to say after they've talked. So I would just, I guess, repeat what they both said, which is I thought that the best part of this argument, and it's really saying something, is that I don't think there was a single question where I thought you gave a non-responsive answer. I don't think that there was a single time when the answer didn't come back and it was an attempt to answer that question. And some of the answers were better and some of the answers are worse, as is always the case, because sometimes there are good answers and sometimes there are bad answers. Sometimes you think of the good answers and sometimes you think of the bad answers. But the most important thing is that you're actually listening to the question and trying to figure out what lies behind it and answering that question and not something of your own devising. And I thought you were all exceptionally, exceptionally good at that. And in a similar vein, really good at understanding that this is supposed to be a conversation between the judges and the lawyer. It's not supposed to be your sort of time to stand up and recite your talking points or recite the most important parts of your brief even. But it's supposed to be a time where you listen to us, figure out what we're concerned with, and do the best you can to assuage those concerns. And I thought really all four of you were fantastic at that, and that's what made this a really excellent oral argument. I've seen a lot of oral arguments. I've done a few as a judge, and because I spent a large part of my time in law school, I've seen a lot of oral arguments, and you should feel really, really good about this one. It ranked high. So thank you very much, and congratulations to you all again, and thanks for all your hard work. I know that everybody at Stanford, I mean, this is a great day for the law school as well as for the four of you to see this kind of event and to see Stanford represented so well. It's a real credit to the school and to all of your professors who helped you. And so we thank all of you, and thanks Stanford Law School.